Welcome everybody to this webinar brought to you by Ubindi and Conscious Counsel. Our topic today is legal essentials for wellness teachers. Your presenter will be Cory Sterling, founder at Conscious Counsel. Cory is not just a lawyer, but also a yoga teacher and author of the Yoga Law book. Conscious Counsel is a law firm that specializes in serving wellness businesses all over the world. A quick shout out to our sponsors, Yoga Trail, a global yoga network that connects yogi with yoga providers in every country in the world, and Ubindi, super simple booking and admin software for independent instructors. All right, let's dive right in.
Wonderful. So nice to be with like-minded people. I'm a big fan of microphones off. Well, I guess if I'm speaking about something substantive, microphones off, but permission to interrupt me all the time as we do this, like, hey, Cory, I've got a question, or can you explain something like that? And before I get into a little bit about a couple of the things that I wanted to speak about today, thank you very much, Jake, for being on the call and for posting our legal checklist. So before we get started, the biggest thing that we'll hear from people about the law is the following expression: I don't know what I don't know. So they'll be like, yeah, well, I know that I'm operating, but I have no idea what it is, that I should be thinking about. Even I don't know where to start when it comes to law. So we've come up with a free yoga checklist, a yoga law checklist that sort of can let you know for your yoga business, what are the different blind spots you may have? What are the things that you want to think about, and sort of what issues there are. And Jake, if you don't mind, if you can just post a link to the Yoga Law book as well. So I wrote this book called the Yoga Law book, and I started as a lawyer working at a big law firm. You can unmute and boo. If you want, you can boo when I say, when I worked at a big law firm.
Boo, boo, boo.
Boo, yeah. It wasn't all booze, it was mostly booze. But my first client actually that I ever worked for was a tobacco company. And I was hired to come up with evidence to support that smoking was not a dangerous activity. And it was like, this was after all my time in law school, and I studied really hard, and I became a lawyer to make the world a better place. I was like, I'm in the wrong place. Because that obviously didn't align with who I am and what it is that I want to do. And so over time, at the time that I was working at a big law firm, I was practicing a lot of yoga, and all of my friends were in the yoga space. And I went to a class one time where someone got injured, and we were practicing outside of the studio, and there were no waivers of liability. And the teacher was my favorite teacher, who also had like a super young family and no insurance. And it was just one of those moments for me. I was like, oh my God, doesn't she know the repercussions of what could happen, based on this? And then when I spoke to her, it was just like, she had no idea what was going on. And then the first year after I started my business, I went to India. I lived in an ashram for a month, and I traveled around, and I was getting more into yoga. And the more and more that I connected with different yoga professionals, the more that I saw that no one really understood anything about the law. And that, like, for the most part, yoga professionals and yoga studio owners, and also over time, it's grown to Pilates and fitness and personal training and, healing, all sorts of different disciplines under the umbrella of health and wellness, that they're awesome at their gift. They're amazing at leading a class. They're amazing at building a community. They're amazing at having a heart-leading message. But often they don't really understand the ins and outs of the law. So we've sort of positioned ourselves at Conscious Counsel to work specifically with what we call heart-leading health and wellness entrepreneurs. And the whole pay it forward concept for me, and like the big why for why I do it, is that I know that in being able to help heart-leading people who are building communities operate safely and at best legal practices, they'll be able to better support their communities and build their business and help more people. So that's really sort of like a gist of the background for how we started and what we've done. Alex mentioned a really important word in his introduction, which was anxiety around waivers of liability. So my promise to all of you is that after this call, that we're going to leave feeling empowered, and we're going to realize that we had a lot of fun learning about the law. Total promise. We're going to get there. I know it. And that's because I think the most important thing is understanding how we look at the law and just basically shifting the paradigm around what we think law is and how we feel about law to what law really is and how we can leverage law to protect ourselves and our businesses. And the first sentiment that I want you to know that I get is that you may not want to have any interaction with law. You may want to be like, cool, I just want this taken care of for me because I don't really want to worry about it. That's the relationship that I have with my accountant. Anyone, hands up if you have that relationship with an accountant in your life, where you're like, I don't read numbers, I'm not interested, just like you take care of it and I'll smile and drink onion juice. That's sort of how I've been operating for a while. But I understand with law that like, the goal isn't to teach everything we can about the law, but the goal is to teach the most important things that you need to be aware of. So that being said, my commitment during this time that we're speaking together, my commitment to everyone is like that you will leave with practical information that you can implement. So it's not like I'm going to talk about, oh, and this statute was passed and blah, blah, blah. That's not what this is about. All of us are small business owners or studio owners. All of us have questions. And because all of the clientele for our business are small studio owners or entrepreneurs and professionals, I know the issues that you're going through, and I know the issues that you don't know that you have. So I want to share those with you. The one thing that before I really get into it, the one thing I want to stress is like questions are 3,000% welcome. So like, this is your opportunity. You're speaking with someone who understands this industry and someone who has worked in it for 4 years. We've got hundreds of clients. We've got more than 250 5-star Google reviews. I know what I'm talking about. So if you have any doubts or uncertainties, please do speak up and just be like, hey, Cory, can you explain a little bit about this? Or I was wondering about this. Thumbs up if everyone's cool with that. Cool. Now I feel wonderful. Okay, so I'm gonna start with waivers of liability, but the first story that I want to share with everyone is a really important one and a foundational one when we think about why it is that we should work with a lawyer and why we should have our legal documents in order. So the story is a story that happened to me the first day that I actually got called to the bar and that I became a lawyer. So I had a mentor, his name is Mike Stevens. And in, leading up to the time before I actually became a lawyer, he was my mentor. We would have check-ins and he was great. I loved him. He taught me so much. And the day that I actually became a lawyer, he's like, hey, Cory, I'd like to take you for lunch to celebrate you becoming a lawyer. So I went, right? No one in their right mind would refuse free lunch. Logically, I was like, I don't even care what advice this guy has. There's a free meal. I'm going to be there. And so I went with him and he's like, okay, Cory, congratulations. Now you're a lawyer. So I can really share, the one most important piece of advice that you're going to need to know as a lawyer working with small business owners. And I was thinking Martin Luther King. I was thinking social justice. I was thinking doing the right thing. I was thinking transparency of law. I was all of the utilitarian and idealistic reasons why one would become a lawyer. I was like, cool, we're going there. And he's like, Cory, this is the only thing that you need to know to tell your clients. You're going to tell your clients they can pay you now or they can pay you later. And like my jaw dropped. I don't really know what this guy's talking about. I was like, what do you mean? He's like, Cory, you're going to tell your clients they can pay you now or they can pay you later. So naturally, I was like, okay, Mike, what do you mean by that? And he said, any small business owner will inevitably interact with the law. It is impossible that you can start a business, have the business support your life, and continue through the life course of that business without needing a lawyer or without needing legal documents. And what you're going to tell them is that even though they may not want to, the initial investment that they make, which is the pay me now, is, they work with a lawyer, they have documents that are custom fit to their business, they understand the legal relationships they have. If they're signing a document, they know that they're protected by it. And in doing so, they've made the investment up front to protect themselves down the line if there's a problem. Conversely, you're going to meet clients who are going to be pay me later clients. And pay me later clients are clients who start their business, love the idea of marketing, love the idea of brand Bibles and beautiful websites and Instagram and all the other things. And they're going to be like, I don't need one of those agreements. But then 3 months, 6 months, 1 year, 2 years down the line, there's going to be some legal issue and they're going to have to pay you later. And the amount that they're going to pay you later is going to be more than 4 times what they would have paid you up front. And it was such great advice that I share it on any call that I give. You definitely do not have to work with me. You work with whoever it is that you feel aligned to work with. But I highly recommend getting legal documents that are custom to your business because, and as we talk about, there are risks to operating and there are risks that we may be blind to. But the important thing is that you understand that law is an investment up front, the same way working with a bookkeeper or an accountant is. And the idea is that they put you in a position to succeed, and then you get to do the things that you love, offering classes, doing retreats, workshops, teacher trainings, whatever it is that you love doing, you get to do all of those things, but you need to have the right foundation in place. And what I've learned in running my legal practice for 4 years, I call it either proactive law or reactive law. And proactive law is like, hey, we've got the agreements in place. So if an issue comes up, it's really easy to resolve it. We have an agreement that reflected the relationship we wanted to have. Take a screenshot of one of the provisions of a service agreement, of a waiver of liability, of a privacy policy, whatever it is, send it to someone. Then like something that could be a massive complaint just dwindles down and goes away. Whereas if you don't have those agreements in place, then when that problem comes up, it just expands and grows momentum. And then you're stressed, you have got anxiety, you can't sleep, you call me crying. I've received several phone calls, unfortunately, from people who are like crying. And I'm like, the first thing I would say is like, it's okay. Like whatever you're going through, I've been through this before, but there's an easier way. So that's sort of like the one thing that I just always feel obligated to share, the importance of organizing things properly from the start. I'm going to start with waivers of liability because to me, that's the most important document. And I'm going to explain exactly why. But at this point, does anyone have any questions or something that you want to make sure that we cover? Feel free to unmute yourself and let me know, and I'll make sure that we address it. Okay.
Can I ask you a
Yeah,
question?
Jennifer.
I'm a certified yoga therapist opening up a private practice next month. And I'm wondering if, as a yoga therapist, there's any difference, if you are aware of any differences between a yoga teacher, because Yoga Alliance oversees teachers, International Association of Yoga Therapists oversees yoga therapists, so different organizations.
Yeah, it's not even just about the governing body or association that gives the credit to you. That's the legal issue with the yoga therapists. The most important thing about everything that we do in law is about communicating expectations openly and honestly. And where we see the issue of yoga therapists coming that I've seen with all the clients that we've worked with, it usually has to do with representations of what your qualifications are and being super clear to people what you can do and what you cannot do and what you've studied, and that you're not a therapist in terms of a medical therapist and what that means for the relationship. And that's sort of the same with, in a different way, it's similar with health coaches, what we see come up with health coaches, because health coaches will often try to do similar things that come from, sort of mandated, regulated industries, like being a dietitian or being a naturopath or being a doctor, right? There are rules around what you can and cannot do. So for a yoga therapist, we have specific documents that deal with all of those representations, and then also having the waiver of liability to count for all of sort of the emotional work and other things that you're going to do in working with them. Does that help?
Yeah, that helps a lot. Can I ask one more?
Hold on. First, what was your snack today?
My what? Oh,
Your
snack.
snack.
I put down a chai latte.
Cool. Take it.
What about touch? Do we have to have that in the liability waiver? Does it matter by state? I'm unclear. It's not in my waiver, but I touch, my
touch in the waivers that we draft, we always have a provision around consent, which and the way that you'll want to draft it is that people are signing the agreement, so they're becoming legally bound. So you draft it, you say, you understand that in working with Jennifer Brandt, that we will be providing on-hands adjustments, right? And so then if someone doesn't want to, they would read it and they would let you know that they object to that. Consent will always be a relevant issue. And I think it's all about everything that I share as a lawyer. It's all about how you communicate with your clients. So I think the best thing, first and foremost, is like, A, be legally protected by having it in your document. And then B, it never hurts at the start of a class to ask someone like, hey, are you comfortable if I provide on-handed, physical adjustments? And if someone says no, you can say, cool, I totally understand that. Because you just have to think, if an issue is going to arise, the complaint would be have to be made by the student. There's no outside body. One thing that we'll learn about in this webinar is that there are certain relationships where it's just you and your clients. So it's about managing that relationship, like a waiver of liability, like a service agreement. But there are other relationships like an independent contractor or employee distinction, where there are other governmental third-party bodies that may intervene in the relationship. So as long as you're managing the relationship with the client, you're in good shape. All good? Cool. Anne-Marie, why don't you go?
All right, thank you. Let me put there we go. So I'm a meditation teacher, not a yoga teacher, but I see it as being very similar. I'm wondering if I don't have a physical space, I'm not actually at the moment doing live in-person classes. Do I need to start looking for liability insurance?
Yes. And insurance, and I'm going to answer. So Anne-Marie, I'm going to answer that question 100%, and I'm just going to use it as a segue into waivers of liability.
Okay.
So thank you very much and lovely to meet you. What was your snack today?
Oh, chocolate, definitely chocolate.
I need chocolate. I don't know about you guys, but well done,
It's
Anne-Marie.
a go-to.
Yeah. Nothing chocolate. No one's going to be complaining about chocolate. Okay. So, I'm going to make sure that I answer Anne-Marie's question about liability insurance. And so just to sort of get into waivers of liability and why it matters so much. The thing that we have to understand is when we are facilitating an experience for another person, or we are facilitating a service, we are accepting responsibility that person will not suffer damages while they are in our care. And the legal term for that is called a duty of care. So someone leading or facilitating an activity at law automatically has a duty of care to make sure that whoever is participating will not suffer damages or be worse off as a result of the facilitation. So let's say nobody signs anything. The starting point is, I'm leading meditation, or I'm a yoga therapist. I have a responsibility to make sure that my clients are safe and at a minimum are not hurt or suffer damages in working with me. Now, there is a document called a waiver of liability, which allows a facilitator for an activity to get their participants to sign a document saying, hey, this is exactly what I'm doing. These are what the risks are, all the things. And I'm going to go into all the details of what the elements of a waiver of liability are in just a second. But as long as the document is properly drafted, someone is allowed to sign that document, and that relinquishes or waives or releases that person from liability. And so while the duty of care at law does apply, so long as the waiver of liability is properly drafted, it means that the person is no longer responsible for what happens in that relationship, because you've told them what you're doing, you've told them what the risks are, you told them what the outcomes of the risks are, and you've communicated openly and honestly with them the whole way. Now, so the reason, and then I'm going to explain okay, two quick things. One is, and when I wrote the yoga law book, I researched all these waivers of liability across all of these different industries, because people would always say to me like, well, I heard waivers of liability don't count. Hands up if you've heard that evil myth that someone is spreading. Yes. So I did a lot of research into that, because I was like, okay, well, I'm going to be spending a lot of time in my life working with waivers of liability. So obviously I want to make sure that this is a efficient document and actually works. Now, the issue is that waivers of liability will stand. There's Supreme Court rulings where a waiver of liability has protected a person or a company where they otherwise would have gotten sued. The issue always of when a waiver will not stand or not apply is if it is not properly drafted. That's what it always comes down to. And so that's why for us, we're so draconian, like friendly draconian, when it comes to ensuring that a waiver of liability is specific to the activities that you're providing. Because the whole rationale, if you're following everything that I've shared, the whole rationale behind a waiver is like, cool, this is something that's actually pretty serious. Like, otherwise, you know, if someone's, the agreements for someone to sign up for Netflix, okay, they don't, it's less serious. The repercussions of that relationship are less serious. So the legal hoops that you have to jump through for signing up for Netflix are more relaxed. But remember, with a waiver of liability, we're talking about someone signing away their legal rights that they otherwise would have. And that's why the bar is so high. And that's why a waiver of liability has to be properly drafted. And so the thing that I want to say, and I went in depth in this in my book, which explains waivers in much more depth, but it's that yes, waivers of liability do apply, but it always comes down to how specifically it is drafted. And like, if anybody wants a magic answer, because I'm about to talk about, you know, activities, and I'm going to talk about equipment and where the activities are done and all of those things. If you want to know, like, how specific do I have to be? What I always tell clients is you want to reverse engineer it. So reverse engineering, it means, okay, I have a yoga therapy and a yoga practice, and I'm working with clients. What are the possible damages that someone could suffer? What possibly could happen in them working with me, or what could possibly go wrong? And does the waiver of liability adequately address this? So I'll give an example. I've defended waivers of liability. I've been involved in negotiations and lawsuits where we've either settled or claims have disappeared, and we've relied 100% on a waiver of liability. An example where a waiver of liability worked, it was a specific yoga studio that was doing aerial yoga. Does everyone know what aerial yoga is? Aerial yoga is like, you've got these silk straps and people hang upside down, and why wouldn't there be a legal issue around it? But someone got injured using one of the straps, and the waiver that we had drafted was very specific about, you're going to be using aerial yoga, you're going to be in these positions, this is how it works, this is the height that you're going to be at in the event that you fall. And like, we told them, everyone who signed the waiver, it was super, super specific. Unfortunately, a person got injured. They were doing something the instructor did not tell them to do. And then look, this is how it always happens. And if the question is, why does the waiver matter so much? Because it's unforetold how much you may be legally responsible for. So in this case, the demand letter that the studio got that I was working with, the woman who got injured was 28 years old. She was in New York City. She had an executive job. She was earning more than 6 figures. And as a result of falling from the aerial silk, she was not able to look at a computer screen. She was not able to work. She had post-concussion syndromes, all of these problems that, like, I don't know if she really had them, but that's what the lawyer was representing that she had. And like, sure, in good faith, I accept it. But then you have to understand, at law, there's something called quantum of damages. So then they're looking, okay, well, this person normally earns X, and they're 28, and they were going to work until they were 60. And now, and like, God forbid, if there's an accident where someone's quality of living changes significantly, this is the process that they go through. And then that number of what they're looking for, or what they feel is fair to, be put whole and fair again, is astronomical. And so in this instance, we relied, they said, you know what, the teacher was negligent, it wasn't blah, blah, blah. They throw the whole kitchen sink to explain all of the problems. And we just say, like, look, this is the document you signed. The exact injury that took place was the exact injury that we warned you about. And as such, you've given up your legal right to seek a claim against us. And that's like, that's the crux of what you want a waiver to do. So if you're doing a waiver on your own, I think that's really cool. I feel like someone doing a waiver on their own would be like me looking at my car. Does anyone know how to fix a car? When people tell me, they're like, yeah, I did my own waiver. I just see myself in front of my car under the hood, making a lot of, not doing the right thing. That's why I give it to a mechanic, but that's totally cool. But so I'm happy to support you and provide this information. But the thing that you want to think about is, okay, if something materializes and one of the activities that we have, the risk actually happens and the person suffers a damage, on a strap, doing acro yoga with blocks, with balls, with whatever it is, did the waiver adequately represent that risk? And so I saw there were a couple of hands up. And so I'm just going to wrap up. I think it was Danny, and I forget who else it was. If you have questions, I'll take them in 2 minutes. But just to go through like what the elements of a waiver of liability are. Okay, so the first thing is you have to be as specific as possible about what activities you are doing together. So number one is what are the activities? So the activities could be personal training, it could be high intensity interval training, it could be only meditation, it could be yoga, it could be yoga therapy. You want to write out all of the things that you plan on doing and all the things that you reasonably foresee doing. So as an example, let's say you have a general waiver that is just a yoga waiver and it doesn't say anything about prenatal or postnatal yoga. But then you decide to start doing prenatal and postnatal yoga. That is something that's a different type of activity. And so that's something that should be listed with the activity. Thumbs up if that makes sense. Cool. I'm happy that makes sense. And now the other thing is that when you're looking at the activities, like pre-COVID, my spiel would stop there. I'd be like, okay, activities, you're doing this, you're doing acro, you're doing personal training, dumbbells, kettlebells, Pilates, reformer, Cadillac, whatever, all the things. But now now this is where I'm coming into Anne-Marie's answer. You're also going to want to include things like if the activities are provided online or in person. And you're going to also want to include if the activities are being performed outdoors or indoors. And you're also going to want to include things like, are the activities pre-recorded or are they happening live? And the reason why, and again, remember the first thing I said about waivers and all of the research, it's all about how closely it is drafted to what you're actually doing. And the reality is this: someone who's doing some form of physical activity or a meditation practice through a pre-recorded outlet it's a different activity with different risks than if you're guiding someone through a practice in person or even online. So that's, and then additionally, and it sucks, but the activities now are also the activities, if done in person, are also taking place in an environment where there is a communicable disease and blah, 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 blah. So now to answer Anne-Marie's question, the magic equation for all of you is going to be legal documents plus insurance equals smiley face. Okay? And I love smiley faces, and I'm all about, I promised this was going to be fun. So I'm smiling. I want you guys to be smiling as well. But the thing that you have to know, Anne-Marie, and we started going through this with our clients in April 2020, is that we see that there are different insurance providers who they don't really have blanket insurance. So they may allow you to do things in person and outdoors, but they may not allow you to do things online or pre-recorded. Pre-recorded of all of them seems to be the one that people have the biggest, that insurance companies have the biggest issue with, where they're like, no, we're not touching that. And I don't know, maybe it's just because it's unsupervised, there's a higher possibility of someone claiming insurance fraud as a result of it. I have no idea why. And I don't know the answer, and doesn't matter. But the thing that you want to do, Anne-Marie and everyone, you want to play a really fun game. This is if you've got kids, you're going to tell your kids about this game. They're not going to believe it. And it's also totally free after you paid your insurance policy. So you're going to prepare your favorite snack. It could be a chai latte. It could be chocolate. It could be iced spaghetti. Okay. If it's iced spaghetti, that's a good thing. and you're going to prepare your favorite snack, and like you're going to put on your favorite song, and you're going to think, whoa, I'm feeling good today. Look how many wonderful things there are in the universe, and I have so many reasons to be grateful. I'm going to call my insurance provider, and I'm going to get them to confirm that all of the activities that I do are covered by my policy. And so the first step of the game is preparing your food. The second step is putting on your favorite song. And then the third step is you just make a list of all the different activities that you do and the ways that you do them. And then you find whoever your broker is or a representative, and you say, hey, how are you today? Happy Thursday. I want to confirm that I'm covered to provide the following activities in the following ways. And then you read off the list. And then they're going to say, yep, you're covered for that, or no, you're not covered for that, or whatever it is. But like, you just do it once, have fun with it. And that's the insurance game. So I'm going to continue with the elements. But so Anne-Marie, I hope that answers your question. But like, the key is you want waivers, you want legal documents that are specific to your business and what you do, and you want to speak to your insurance provider and make sure that you're totally covered. And really, with those two pieces, like 99.99999%, you're cruisy. You don't have to worry about this. The anxiety disappears. Go out, get as many clients as you want. Don't worry about working with strangers. All of the things that I'll typically hear about what people don't want to do. You don't have to. Stephen, why don't you go for it?
Yes. So you mentioned pre-recorded. So when I do my live classes, I pre-record them and I load them up on YouTube. I have free access to anybody, but
Yeah.
I put on there, I say at the beginning of the video, if you're experiencing any kind of discomfort, blah, blah, modify as you need or skip poses altogether. But I am not asking anybody to sign anything. So it's anybody at any time, anywhere in the world watching this video is just doing it, and I have no documentation whatsoever exchange with the person. What happens then?
Yeah. So firstly, Stephen, what was your snack?
A Greek yogurt with almond butter and blueberries.
Yeah, I remember that. I remember seeing almond butter. It jumped out at me. I was blown away. Okay, Stephen, great question. So waivers of liability are the gold standard. So why are waivers the gold standard? It's a signed, legally binding document that someone is relinquishing their right to sue you. They're waiving their right to sue you. They're saying, normally I would have these rights, but because you've adequately described to me all of the elements, which I will return to in a waiver, I will not hold you responsibility. That's what you always want if you can. At Conscious Counsel, we came up with something that we call a social media disclaimer. And this is for our clients who run Instagram live classes, Facebook live classes, and YouTube classes. The problem there is that as you understand the issue completely, that you're putting this content out there and that anyone can access it, and you're not able to oversee who's doing it, how they're doing it, anything like that. You sort of have this at the start of your and I don't know the specific content, so I can't comment, but you want to have a disclaimer on your website that's linked to your YouTube channel, and just a general disclaimer that says like, hey, Stephen uses the following social media handles. And Alex, I'll answer your question in a second. And you understand that in participating with this, you accept all of the risks. You're medically fit to do so. You're voluntarily participating. If you don't feel comfortable, you'll stop. All of the things that you'd have in similar things to have in a waiver are there. But the reality is, if a waiver of liability is the gold, a social media disclaimer is the bronze, because someone's unilaterally participating. And let's go through an example. Let's say you put content out there and something in the information you share is incorrect, or getting into a posture, you've explained it incorrectly and someone gets injured as a result. They have not signed away their legal right. They have been informed by you that, you will not accept responsibility and blah, blah, blah. But it's sort of the best that you can do in that situation. But the best thing for everyone to do in every situation is get as many people as will be participating to sign a waiver of liability. I'm going to pick up. Look, it's possible that YouTube terms would cover you, but Alex, the way that it works when someone wants to sue someone, it's called a fishing expedition. And what they'll do is they will throw a net as wide as they possibly can. I'll share a brief story. And so to finish the answer, yeah, maybe they would name you, they would name YouTube, they would name all of the different things that they can. But the reality is, if somebody wants to sue you and someone is determined to sue you, legally, they would be allowed to. And you want to do everything you can to avoid that situation. That's why, like in the pay me now, pay me later story, let's say you've got a social media disclaimer, person X in whatever part of the United States sends you an email. Hey, I was doing Steven's yoga class, and when he was explaining Scorpion, it was done incorrectly, and now I've pulled my back out and I work as a construction, blah, 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 whatever it's always the same story. When you can copy and paste, when you can copy and paste a copy of that disclaimer, hey, you did this at your own risk, that's a really important step in slowing the momentum of their claim. And another thing that I want to share just about how law really works. So to answer your question, it's like, yes, but if someone is determined, they will sue you. And if there's a lawyer who's working on a commission payment for how much they get a settlement for, they will exercise all options. And YouTube does not indemnify you, right? YouTube doesn't say, oh, like our legal counsel will make sure that you're protected. YouTube's just going to protect itself, which is how I would imagine a situation like that would unfold. Does that make sense? I was going to share how things actually happen. So this is also really important to understand, because like what I often find is I'll work with clients and they're going to be like, okay, well, blah, blah, blah. And what happens when I go into court, right? And thank God, knock on wood, that's a real piece of wood that I'm knocking on. Thank God I've never had an instance where anyone has gone into court. And that's because I think most people don't understand what the process is and how the process works, right? So first things first, going to court is like a process that takes years, and it is extremely expensive for both sides. And like, there's nothing guaranteed. So people are very, very reluctant. The situation is always as follows. Complainant A will make a complaint to business owner. Either it will be them in an email, or they'll hire a lawyer that will be like, you're terrible. This is why everything that you've ever done is wrong. This is how I got injured. You read the letter, you're like, oh my God, I'm the worst person. I can't believe all of this happened. Until you send me an email and you're like, Cory, I got this letter. Cool. This is just called a demand letter. So what happens is someone wants to file a complaint. Someone is threatening to sue you. They're going to send you a demand letter. Now, the thing to know about the actual process, and I've been through this many, many times, so I'm speaking from the heart. You receive a demand letter. Someone is thinking how they want to sue you. Everything will depend on what your first response can be, right? So if your first response is organized, professional, put together, hey, this is the document you signed, provision 7 says you're not going to sue us. This is how you got injured using the TRX. The waiver specifically mentions a TRX, blah, blah, blah. Therefore, you have no claim. We hope you feel better. We're really sorry. You've taken all of the momentum out of that. That person, if they've not sought a lawyer, they will seek the help of a lawyer. They're going to present that information to a lawyer, and the lawyer's going to look at it and be like, I'm not really touching this. Because usually when it comes to lawsuits, people don't have the money up front to pay a lawyer. So they'll pay a lawyer who's going to work on commission. So a lawyer is like, some lawyers are sharks. And when they smell blood or they see blood, they're like, oh, this is amazing. This is so great. But if you're able to respond promptly, professionally, at best legal practices, it takes the momentum away. And then A, they're going to lose motivation to continue harassing you and trying to get money from you. And B, they're going to, if they go and speak to a lawyer, a good lawyer will not waste their time on a file like that. Conversely, if you don't have the legal documents in place and one of these issues comes up and your response is like, oh no, but I told you that you might get injured, or I said in class we were going to use TRX. It opens the door, they get momentum, they realize that you don't have the foundation, and then it's like it's pedal to the metal. And I just shared this, like I mentioned proactive and reactive law. I always want my clients to be in control of the situation. I don't want you to be at the whims of someone who's making some alleged claim against you. And like, this isn't fear mongering. It's just real practice. So, and so just so you know, typically when we go through situation A, there's a demand letter. I'm able to respond on behalf of the client. 9.5 out of 10 times it ends there. We'll never hear anything back because most people are scared of lawyers. They don't know how friendly they are and that they make things fun and they drink onion juice, right? If the other side knew I was drinking onion juice, I would be in trouble. But they, it's a lawyer who has a professional tone. And so they're like, oh, okay, I better not start with this. And then 9.5 out of 10 times it'll just fade away. In the event that it does move forward, it will fade away shortly afterwards. Like, I've never been through something that's been carried through, just because when you work with the right lawyer and they're responding, there are different things that you can say. Like, for example, if someone wants to bring a challenge against you or file a suit against you, you are allowed to claim legal costs against them in the event that you are victorious. And so usually that's enough to scare someone where they're like, oh, not only may I not win, but there's a possibility that I have to pay this other person's and pay this other person's legal bills. And also it usually will just end in some form of settlement. Like, I've been part of settlements where it's been an apology, where it's been, a refund of a month of services. Like, there's a million different ways to skin a cat. Did I get that? Is it skin a cat? Should be skin a sheep. Don't you sheep? No? Anyways, just sounds weird to me because I don't know anyone who skins a cat, but I'm sure there's, anyways, I'm over that. But basically it's in the real world, the way that it works is demand letter, response, strength of response and strength of documents. And then it's like, either this is something you're worried about, you're staying up all night, you're not focusing on building your business and the things that you love. Conversely, it's taken care of for you, the problem goes away and everything's sorted. I just want to make sure I'm going to go back to the elements of a waiver of liability, and we've got 10 minutes. And I'm happy to go for a couple of minutes afterwards, obviously, because I showed up late, and my apologies again for that. So the first is the activities. And remember, that's what you're doing. That's what equipment you're using, online, in person, pre-recorded, all of that stuff. And then we combine that with our insurance to make sure that we're totally covered. The second is, what are the risks of those activities? So with you, I'm going to be doing spinning classes as an example. Okay, what are the risks of participating in a spinning class? The risks are that, there's going to be cardiovascular activity. There's a possibility that I fall off the bike. There's a possibility that the bike's not set up properly. Whatever it is, all these different things, you're doing this activity. What are the risks of that activity? Once you define the activities and the risks, the next element is, what are the outcomes of the risks? So the outcomes of the risk could be, physical damage. It could be, mental damage. It could be, if you're doing something, therapy obviously is more far reaching into the personal side with a person, but it could be things like broken bones, musculoskeletal issues, cardiovascular issues, heart attack, death, because the reality is anyone could, an unfortunate circumstance could happen anywhere where someone suffers a heart attack in any particular circumstance. So you want to make sure that the waiver covers you for all of those things. So the big three are, what are the activities? What are the risks? What are the outcomes of those risks? Once you've told someone all of that, then the next thing that you're going to do is you're going to get them to say that they're voluntarily participating. So you've been so straightforward with me. You've told me everything. I understand exactly what I'm doing, how I'm doing it, what the risks are, what the outcomes of those risks are. And I agree to voluntarily participate. As well, you want someone to affirm that they're healthy enough. So I've told you exactly what we're doing and how we're doing, copy paste what I just said. And you've sought medical advice that you are healthy enough to participate. And that's an affirmation that you're making. And then lastly, it's the release of liability. So we've told you everything we're doing, all the risks, all the outcomes. You're doing it on your own. No one's making you, and you're healthy enough to do it. And as such, you release us of any liability, however incurred. And those are all of the elements to a waiver of liability. So I'm happy if anyone has any questions, I'm happy to answer any questions on that. Go for it, Alex.
So this is a question about signatures. Ubindi has a waiver feature built in for teachers that basically presents a document to their students, and they don't sign it digitally. They click a button that says, I agree, like a Facebook terms of service or something. What are your feelings about that?
My feelings are the most important thing, way more important than if it's an e-signature or if it's a click or whatever it is. The most important thing is that someone has to read the reading or the viewing of the waiver of liability should be mandatory before someone is able to proceed. Because look, if someone is trying to dispute a waiver of liability, they're going to come up with every excuse in the book that they can about why it shouldn't apply. And one of them, and I've seen it because I've been there, is that, well, no, my client didn't have a fair opportunity to read it before, or, it wasn't obligatory for my client to read the waiver. So you want the process designed or built so that step one, before you accept any money or before before you accept money or before anything happens, the first thing that happens is someone is presented with the waiver of liability and then they click, I agree. So the discrepancy between a click or an e-signature or a hand signature, the best obviously is a hand signature. The second would be an electronic signature, but a click box is fine. It is 100% enforceable, full stop. It is enforceable. But if someone's coming up with an argument or they want to say something, and there was a recent case that came out where someone challenged a waiver of liability because the waiver was built in with another agreement and all they had to do was click once. So what their argument was, well, my client, it wasn't clear to my client that they were signing away their legal rights because in the same document, they were agreeing to membership terms. So the waiver should always be standalone. And ideally you would want either, like, if you could electronically do initials on the pages, that's awesome. Or an electronic signature, that's great. But there's nothing incorrect about the checkbox, but you just want to make sure that the process is set up correctly to ensure that it will apply. Does that help?
Yeah. So the way it works is the student can't register for class or pay for anything or do anything until they agree. I'm a little worried that you're saying that the liability waiver has to be distinct, or ideally should be distinct from, I don't know, refund policy and other kinds of terms of service and stuff. I mean, Facebook and these other big tech companies, they have one big 30-page thing, right? And you click, I agree, and that seems to cover them.
Yeah, to be honest, I don't know anything about Facebook's legal team or the type of disputes that they get. The only area that I can speak of, and like, trust me, I'm Mr. Path of Least Resistance. I love things to be as simple, as streamlined as possible. The one thing that I've continually seen around waivers of liability is, like, firstly, don't mess around with it. And secondly, just because this recent case that I read, and I'm happy to send you a link so that you can see what the issue was in that particular case. For me, best legal practice is that the waiver of liability is separate. And that could be 2 checkboxes. It could be something else. You guys do what you're comfortable with. I love you. I think you're great. You'll make the decision that's best for you. That would not change what my recommendation for best legal practice would be. And so so that's everything on waivers of liability. The one thing that I just want to share with everyone, and I'm going to end quickly with trademarks, because I think if I only have 2 things that I would get to chat about, it would be waivers and trademarks. I'm just going to put in the chat with everyone, I have a link for a free consult with me. So what I'll say is, like, I love working with awesome people. If the information that I've shared today, I mean, unfortunately, I didn't have enough time to go in things like membership agreements or service agreements or all of those other things. But if what you've heard resonates and it sounds like you'd like to get your legal stuff in order, feel free to book a call. I open some times for tomorrow afternoon, only for Ubindi. Probably, is this going to be recorded and sent out? Okay, so then those people will have to book for later in the week, but like I'm going to leave this open for the next hour, and tomorrow's Friday. So I'm going to take all those times off. So if you want to book something, happy to chat with you, understand what you're about, and get to best legal practices. The other thing that I just want to sort of share about are trademarks. And trademarks are sort of like the sleeping giant legal issue that I always come up against, that are one of the easiest things to resolve. And basically what a trademark gives you is exclusive use over a business name or a trade name or a slogan or a description of your services. And the legal exclusivity is really important, because I've recently had a whole bunch of issues with clients who were using a business name for years. They were never concerned about trademarking. They had the intention to continue the business for years. But then someone else registered the trademark before them, and then sent them a cease and desist letter and said, hey, because it's quite common in the health and wellness spaces for there to be similar names for businesses. And so we receive a demand letter from someone that says, hey, we registered our trademark application on August 25th, 2021. We see that you're currently using a mark that would be misleading or confusing to the public. Please change your website, change your business name, all of these things. And it really sucks when you go through that with a client. That it's something that I always just say to someone, like, if you know your business name, if you're committed to it, if you plan on growing and sticking with it, registering for a trademark can be a really good, a really intelligent step for protecting. It's an investment for you and your business. It gives you the peace of mind that you'll always be able to operate with that particular name or program name or slogan. But in addition to that, if you see someone else using it, you're allowed to ask them to stop. And you also avoid the situation of someone sending you a letter out of the blue being like, hey, you have to stop using this. And the only legal thing that you really have to understand about trademarks is that if nobody registers, right, the government is pro-registration because it's their system and they collect money from it, and it does organize things in a more efficient way. Let's say nobody registers, and let's say there's two companies with the name Ubindi, right? Not that I'm calling anything to happen to Ubindi, and I'm sure you guys are in great shape, and it's just a relatable example for all of us. So let's say company A has been using Ubindi since
2019.
2019. Perfect. And then there's a new company in New Mexico called Ubindi Adventures, and they started their business in June 2021. So long as neither party registers, whoever has been using it for longer has the better legal rights. But the moment that one of the party registers, automatically they're in the driver's seat and they're in control of the situation. And then it becomes very, very difficult. It becomes expensive and difficult. It's like the classic pay me now, pay me later. Whereas if Ubindi New Mexico 2021 registers and has a trademark, the moment the application is submitted, they're in a better legal position than you. And then it would be on you spending the money to challenge their application. You would have to register your own application. And then it would be probably more than thousands. Well, it'd be thousands of dollars in order to challenge it. So it's sort of like one of those driver seat things about law that are really important and that I just always share. And I hate seeing it. I've just had too many conversations with clients where they're like, oh, I wish I registered my trademark before. And so that's it. We're 1 minute over. What were the fun levels like? How did we do? Thumbs up if this changed your paradigm about law. Fantastic. I'm happy. Yeah, a lot of thumbs up. Nice to see everybody. And just one question, is Ellen Oswantini really in Swaziland?
Yes, I am. And I'm actually also a lawyer, a bankruptcy lawyer. So
cool. This is, now I'm going to put on my resume that I've co-hosted a webinar with someone like a professional from Swaziland. I've never met anyone from Swaziland. So this is like, that's the well, the Ubindi webinar was the highlight of my day, but meeting someone from how are things in Swaziland today? It must be late.
No, yeah, I mean, it's 8 o'clock in the evening and I just had some spaghetti bolognese. That's why my camera was off. So, but now I'm happy.
Okay, cool. I'm happy that you're happy. So that's it. Thank you guys.